Good morning to everyone. I hope everyone can hear me. My name is Daniel Bill Opio, and I will be your host for today. I will just request the Defenders Protection Initiative host to mute or tone down on the background sound. Thank you so much. Okay, again, my name is Daniel Bill Opio. I am a lawyer and cyber security expert. I want to thank you all for making time to be part of this virtual engagement organized by the Defenders Protection Initiative in furtherance of the program on Talk to Your Regulator. So the gist of today's conversation is pivoted on registration of NGOs with the Personal Data Protection Office, which is an office that has been created under the instrument of the law, that is the regulations that complement, excuse me, the Data Protection and Privacy Act. So just before we delve into the welcome remarks by Yona Wanjala, I would love to give a few guidelines on how we are going to conduct this session. So all microphones will be muted, as I see most are, unless when the time for communication begins and it's been opened up to the participants to make discussions, then you can raise your hand and I'll give you a go ahead. Then you can unmute the microphone, or the host will unmute your microphone, and then you can be able to share your views and thoughts. But also we have the chat section where you can be able to communicate your amazing views, opinions, and thoughts. So thank you again for making time. And briefly to run you through the program today. So we're going to have the welcome remarks from Yona Wanjala, who is the team leader of DPI. And after that, we'll have the keynote speaker, Mr. Stephen Okello, the executive director of the National Bureau of NGOs, who take some 20 minutes also. And then after that, we'll have regulatory remarks from 10:30 to about 11:20 a.m., where Ms. Stella Alibatese, the executive director of the Personal Data Protection Office, will be responding to a number of questions that have been raised to her. And we'll open this for discussion to all the participants and the regulators as well. Then we shall have closing remarks from Yona Wanjala. I'm going to be very strict on time, seeing that we have strictly 2 hours on this platform. So I hope everyone will be able to adhere to the strictness of the time schedule. So just before Yona delves in, I just want to probably give a brief introduction that the NGO Bureau issued a statement, dated October 7th, 2022, requiring all the NGOs pursuant to Section 29 of the Data Protection and Privacy Act and Regulation 15.1 of the Data Protection and Privacy Regulations, requiring all persons and institutions that collect and process personal data to register with the Personal Data Protection Office. And there are ramifications that come with failure to be able to make such registration possible within the time frame that has been designated. So it's on the gist of that communication that we are having this engagement to talk to our regulators to assist and make the process easy. So at this point in time, allow me welcome Yona Wanjala to give us the opening remarks. Thank you.
Yes, moderator, Daniel, thank you for giving me this opportunity to make opening remarks on this very important subject that we need this. We feel that the sector has to get reasonable or significant understanding on the implication of the circular that was circulated by the National NGO Bureau to the rest of the sector. Just like Daniel has highlighted, the National NGO Bureau of Uganda communicated a circular number 1 of 2022 on the 7th of October 2022. This circular was basically highlighting the regulatory obligation of the NGO sector to comply with, in line with registration of personal data. And as you know, that Defenders Protection Initiative in August launched a program of Talk to Your Regulator, which was basically creating spaces for civil society to interact or dialogue with the regulators, get to raise concerns, get to seek understanding and seek clarification. We thought it was wise for us, one, to mobilize the sector, to be able to get it directly from the regulators. What is the background? Isn't the time too short? Given the hiccups that the NGO sector players have registered, we are just from the COVID, and given the fact that little is known about this act by the majority of the sector players. So we felt that we need to, one, create this platform and the regulators are able to relay the info directly to the sector players. We are blessed and honored that when we reached out to the regulators, they were willing and happy to share with us all that entailed in the circular, but also deeply what it is in line with the data protection. Who is the ED of Uganda National NGO Bureau. Please, Stephen Okello, you're welcome. We are also blessed to have the Director of National Data Protection, Madam Stella. Please, you're welcome. They will be interacting with us and sharing with us a lot. Our dear regulators, the ED of the National NGO Bureau and data protection. The people on this virtual platform are members of the sector from all across the country. Some of them, upon sharing highlights on this particular event, raised a lot of concern. Majority raised the issue that, one, they did not know about this other regulatory obligation. Others said the time is too short. Maybe we needed to extend it. Others said that there is little outreach that has been done by the regulators in sensitizing the sector players about this obligation. Of course, these are valid concerns, and we deduced it into a statement that we shall be happy to share with you, our regulators, to consider some extension. However, before we land into the gist of the content of the communique, I would again want to take the opportunity to welcome you all, people who have committed their time, people who have committed their resources in terms of data, to be able to listen in onto this platform. I don't want to take a lot of time because we are eager listening from the regulators on highlighting to us what is expected of us, but also us communicating to them what we do expect of them. Most important, the plea on an extension of the deadline. I want to give the opportunity broadly and ample time to all of them. My brother Okello, you're welcome. My sister Stella, you're welcome. I declare this virtual meeting open. Over to you, Daniel. Thank you.
Thank you, Yona, for giving us that introduction. and the brief background, and for also not preempting the communications that are going to come forth from the rest of the participants. At this juncture, I would love to invite our keynote speaker, Mr. Stephen Okello, who is the Executive Director of the National Bureau of NGOs, who also was with us at the launch of the Talk to Your Regulator meeting that happened at Serena a couple of months ago. Mr. Stephen, you're welcome. The floor is yours. You have 20 minutes to take us through.
Okay, thank you so much. And unfortunately, I've just come in. I missed what Yona was saying, but I hope I can correctly guess what he was actually saying. So I just hope that the agenda is still the same so that I'm not off. So let me start by sending my greetings to everyone who is present and also all protocol observed, because there are different people who are present here. But of course, I want to pass a special appreciation to the Defenders Protection Initiative for organizing this, because this is a very important engagement. It's the second one we are having, and I think it is something that has to continue. So I greatly appreciate this. But also I want to pass a special appreciation to the National Director of the Personal Data Protection Office, Stella, who is present here. I made a request to her to be a part of this, and I did not receive any objection or any reconsideration. So for me, I think that is a special appreciation to her that Stella has put aside time to come and be a part of this. All of us who are present here are already aware that on the 7th of October, the NGO Bureau issued a circular where it was requiring all NGOs in this country to register under the Data Protection and Privacy Act of 2019. And of course, it also has its regulations of 2021. The requirement was that they're supposed to register with the Personal Data Protection Office in accordance to Section 29 of the Act. And of course, ever since then, a number of reactions have come up. I've received a lot of questions, concerns. And I think the first thing I want to clarify is that that circular was more of a reminder, and that's what the heading indicated, because the Personal Data Protection Office had already issued a press release in the Daily Monitor and New Vision in November and December 2021, where it gave a grace period to different stakeholders, not only NGOs, but the different stakeholders who are data collectors in one way or the other. And the grace period ran up to the end of December 2021. And that meant that, that they were actually free to now proceed with any measures. But it was good that this circular has been issued, and it was more of a reminder, not that it was a first timer. But of course, the kind of reactions clearly showed that so many people either had not seen that notice or else were just learning about it for the first time, or else they could have seen and just say, everyone, there are clear deadlines that were put there. The 31st of December, no, the 31st of October is the deadline where we expect at least all the affected organizations, the NGOs that are registered with us, have complied. Otherwise, from November, we're going to see the Personal Data Protection Office come out and take some action, some enforcement measures. And of course, also the services the Bureau offers to these affected organizations are going to be affected. We also have seen from previous laws, like, let me say, the Anti-Money Laundering Act, whereby the NGOs currently are accountable persons. I'm aware there's, of course, a debate whether NGOs are supposed to be accountable person or not, but as that debate goes on, the fact that the law is still enforced, then the NGOs will still have to comply, whereby before you get any service from the Bureau, like, let me say, renewal, you need to show us a copy of your certificate that you're registered with the Financial Services Authority. Now, the same is also applying here. The fact that these are laws of the country, they're already gazetted, they're already enforced. It means that our work as the NGO Bureau is to ensure that these laws are being complied with. So this is not a new law. It's not something that, and of course, it's interesting that a number of organizations already knew about it, because I've had discussions with even organizations before this. So it's good that the rest come on board. But of course, some of the kind of reactions I've been receiving, others, of course, up in arms, saying the laws are becoming too many, with so many obligations. Others are saying the space is shrinking, this is becoming too much. And of course, I strongly thank the Defenders Protection Initiative for this, because it gives us a platform to raise awareness on these new laws and its regulation. And of course, the overall purpose of this engagement is just part of the sensitization, because we need to have a clear outreach program whereby we are building the capacity of our stakeholders, so that the motive of this law, the benefits of this law, the principles involved, the rights, the obligations, and any other areas that people should know about come out very clearly. Because by the nature of the work the NGOs do in this country, they are collecting data. And I'm sure others are wondering, why are you dragging us on board? The kind of data we are talking about starts right with your employees. We are aware that NGOs have got employees, whether they're volunteers or not. We are aware that you actually collect their data. You also have beneficiaries. You also conduct surveys, assessments, research, and so many things, and you collect a lot of data. And that means that the NGOs in this country are also data collectors in one way or the other. Currently, I'm having discussions with the Personal Data Protection Office to engage more on the issue of CBOs, where the CBOs are affected. It's something we haven't concluded on. So once we conclude on it, we shall then communicate to everyone and let everyone know. But as we talk now, the main arena is that the NGOs are data collectors, others actually data processors, and that means, and of course, the fact that they're also subjects at the end of the day. Stella will clarify all this as she presents. I do not want the focus to be on me today, because the last time we had this engagement, the Bureau was, let me say, had the lead in discussing together with other stakeholders. I would think that the 2 hours we have, let the focus be on Stella, because she's the main actor. I'm aware that a number of you have brought all kinds of ammunitions to shoot and ask questions. I request you first hold those ammunitions, listen to Stella. Her presentations may answer some of your questions, and if they have not answered, then you are going to have a plenary, I guess, so that you can raise all your questions. So any machine gun, missile, anything you have brought for Stella, just hold on until you are ready to ask the question. So, moderator, thank you so much for now. I'd love to stop there and let the rest of the time be for Stella. Yeah, thank you so much. Yes.
Okay, thank you, Mr. Stephen, for giving us that brief keynote address on where we stand as NGOs and the regulators. Before I invite in Mrs. Stella Alibates, the Executive Director of the Personal Data Protection Office, just a few announcements on the group. There's a link that has been shared on which you can be able to register attendance. Also, I would encourage the DPI comptroller responsible for the link to ensure that access is granted, because I see comments in the group of denial of access to the link for registration of attendance. And I know at the beginning we didn't make introductions, but we'll do that at the end. Why we kept it that way was to ensure that we maximize the time to get the gist of the communication beyond just the introductions. But as Mr. Stephen was speaking, a lot of elements were coming from the private sector, of course. I see issues of data inventories, perhaps later on in the participants segment of discussion with the regulators. Mr. Stephen, you might have to delve a little bit on the creation of data inventories to understand which kind of data amounts to personal data that is being collected and what doesn't amount to personal data. Some of those issues, as also we've been doing private work as ad security with some organizations, we've come to realize that problem is looming. So at this juncture, allow me to welcome Ms. Stella, the Executive Director of the Personal Data Protection Office, who is going to take us for a period of about 50 minutes and will give us an overview of the Data Protection and Privacy Act, probably to create the awareness about the Act, but also why do NGOs need to register with the Personal Data Protection Office. And we'll also look at the steps that should be taken to register with this office, as well as the ramifications and penalties that are present for failing to register with the office. Ms. Stella, you're welcome.
Good morning, everyone. I hope everyone can see me today. I'm very happy to be here. I thank the Defenders Protection Initiative for giving us this opportunity to talk to all of you. I also want to thank the ED NGO Bureau, Mr. Okello, for introducing this topic very well and making it easy for me to start my presentation.
We have lost the voice. We are losing the voice, please.
Ms. Stella, we've lost you there for a while. Probably. Okay, in the meantime, as we are waiting for her to get back on the platform, I think we've entirely lost her connection and connectivity. Probably there are some key elements that we should place emphasis later on what amounts to personal data really, and probably since Mr. Trust, that comes with the idea of being able to submit the registration of the personal data that is collected between NGOs and the NGO Bureau. Levels of data become very privy to the organization that is in question, and where is the line drawn between the organization, should they divulge to the NGO, to the Data Protection and Privacy Office. But also, so I think that is something that the NGO Bureau might have to look into, because sometimes the personal data that is being distributed is in a way intertwined with the general fabric of the personal data of the organization itself. So in as much as the organizations are collecting personal data of individuals and entities, but the organizations also have their personal data. So where is the guarantee that the personal data of the organization that is being given out in submitting the personal data of the individuals that they collect, where is the guarantee that this data will retain the integrity? So the element of trust and how that bridge can be put in place is something that I think Mr. Okello, you later on probably have to touch a little bit. I do not yet know if Stella is back with us. I think Stella is not yet back with us.
Yes. Daniel, Stella had a problem with the laptop, so she's just trying to reconnect again. I think in a minute or two should be back.
Okay. So thank you. Let's hold on there a little. I would have easily introduced Mr. Kellogg, but at this point, probably if you have any thoughts that you would love to later on, you're comfortable to bring through the chat section, you can just type a few thoughts, idea, your experience, if you have already complied with what is needed. But again, just to take us through the act a little as we wait for Ms. Stella to reconnect. There is the act, basically the Data Protection and Privacy Act of March 2019 came into force in that time, 2019, and the regulations came a year later. But this act applies to various categories of persons who may be involved in the flow of data information, and creates entities such as the data subjects. The data subjects are those that own the data and deliver this data, of course, with the principles that have been enunciated in the act, such as consent, which has to be explicit. It doesn't have to be implied. There has to be accountability by the data controller, the data processors, and the act also touches the elements of even, cross-border transfer of data. And I'll be very interested in hearing what Ms. Stella has to say later on the elements of, for example, organizations that indulge in cross-border transfer of data and how the integrity of the data transferred to either, external processors is kept intact. So it applies not only to persons within Uganda, but also those that are outside this jurisdiction, holding information relating to Ugandan citizens. So every company and organization that collects or processes any data is subject to this act. The act on what data generally is. So it could be that which is processed by means of equipments operating automatically in response to instructions given for that purpose. So even if it's an automated artificial intelligence run system or machine learning system, that could also, which has been recorded with the intention that it should be processed by means of that kind of equipment, those ones that are relevant for filing systems, and any of the private information that might not necessarily even form those that were in the categories that are form part of the. I don't know if Ms. Stella is back with us.
I'm back. Apologies for that. I had a challenge with my equipment here, but I'm now able to proceed. Allow me to go through the presentation now. Of course, I had already thanked DPI and the ED NGO Bureau for giving me this opportunity to make this presentation. I'll provide a brief overview of the Act and then also talk about why NGOs are requested or are required to register. Before I start, I would also like to introduce the Personal Data Protection Office to the members present. In 2019, the government of Uganda passed the Data Protection and Privacy Act. And this act enables the regulation of the collection of personal data and ensures the privacy of citizens of Uganda and those other nationalities that are resident in the country, as long as their personal information is collected. The law provides for the National Information Technology Authority as the regulatory body for data protection and privacy. However, within the same act, because personal data protection authorities are required to be independent organizations, the Parliament introduced or established the Personal Data Protection Office which is an office that is independent within NITA and is responsible for personal data protection under the authority. Section 5.3 of the Data Protection and Privacy Act further provides that the office, in performing its functions under the Act, shall not be under the direction or control of any person or authority. So this office is an independent office within NITA. Some of its functions include overseeing the implementation and enforcement of the Act, establishing and maintaining a data protection and privacy register, and that is one of the things we are going to talk about today. It receives and investigates complaints. It formulates, implements, and oversees the protection and observance of the right to privacy of a person and of personal data. It monitors, investigates, and reports on the observance of the right to privacy and of personal data, in addition to many other functions that are provided for under the Act. In answering why the Act, why was this Act put in place? The Act was put in place to give effect to Article 27 of our Constitution. Article 27 of the Constitution of Uganda provides for our right to privacy. And I know as NGOs, you're defenders of human rights, you're defenders of digital rights, and this is one of those rights that are defended or protected under this Act. The Act also comprehensively and adequately provides for matters on data protection and privacy that were not addressed in the previous legal regime on data protection. We have a number of laws that had provisions related to the protection of personal data. One I can mention is the Registration of Persons Act, which is the act that enabled the collection of our personal information for purposes of issuance of national IDs by NERA. Within that law, there's an entire section that talks about what NERA can do with our personal data, the requirement for it to protect our personal data, the provisions on who they can share that personal data with and the like, in a way providing for the protection of our privacy and our personal information. The other law that I can also mention is the RICA Act, which is the Regulation of Interception of Communications Act, which provides for interception of our communication. While many sectors will say that law allows for interception of our communication, they normally forget to add that within that same law, there are certain protections for our own privacy. For instance, interception cannot take place without a court order or without a warrant being issued. Interception can only be authorized by specific people like the IGP, the CDF. There's a requirement for the judge to be able to address those issues. And these were all intended to ensure and provide for our privacy. The law also protects the privacy of the individual and personal data and regulates the collection and processing of personal information. One of the reasons we are here is because NGOs collect a lot of personal information. And I agree with the ED NGO Bureau, Mr. Okello, who indicated that even your staff members are data subjects under this law, and you collect personal information. Personal information includes things like their name, their telephone number, their addresses, their email addresses. Anything that can identify someone is deemed to be personal information under the Act. Now, under Section 1 of the Act, it provides that this law applies to any person, institution, public body collecting and processing personal data within Uganda and outside Uganda in relation to Ugandan citizens' personal data. and then it applies to personal data processed by automated or non-automated means if that data is part of a filing system. Now, when you look at these sections of the law, it is very evident that that NGOs, because they are institutions, they are persons. If we remember, persons in law include legal persons and then the natural persons. Because you collect and process personal data within Uganda or even outside Uganda, but in relation to Ugandan citizens' personal data. I can give you an example. We've had NGOs who have registered with us, but the NGOs are resident in the UK or in Denmark. Why did they register? Because they are collecting personal information of Ugandan citizens, What we've seen are NGOs especially that are dealing with orphanages, that are providing support to vulnerable people. They may not be resident here, but they are already providing a service and they are collecting personal information. So those NGOs, although they are not resident here, they are also required to register, and they are registering because they process data from our children, especially. There are a number of definitions that I would like to talk about for a better understanding of this law. We have data collectors, and those simply organizations or any person that is collecting personal information. We have data controllers, and this means a person who alone or jointly with other persons or in common with other persons or as a statutory duty determines the purposes for and the manner in which personal data is processed or is to be processed. Data processors are those organizations that process personal information on behalf of another organization. We have to remember that processing also includes sharing. It includes storing personal data. It includes, let's say, analyzing personal data. It includes profiling personal data. So the definition of processing under the Act is very wide. We have data subjects, and this means an individual from whom or in respect of whom personal information has been requested, collected, processed, or stored. A data subject, in a simple definition, is myself and yourself, Yona, Mr. Okello, everyone on this call is a data subject. Personal data, I had the moderator asking what is personal data. The law defines personal data from which that person can be identified that is recorded in any form. So when you look at information, the only question you have to ask yourself, can this information identify someone? Can it identify a person? Can it identify a human being? That is deemed to be personal data. We've had questions, for instance, where people are wondering if my personal information is represented in terms of numbers, does that qualify? That wouldn't be personal data unless that data has, let's say, a NIN, it has a passport number, it has a telephone number. If you have data sets that you have anonymized and someone is not able to identify individuals within that data set, then that wouldn't be personal data. We need to know or to recognize that this law only handles issues related to personal data. So if there are issues to do with your formulas, if there are issues to do with your patented policies or tools, if there are things to do with trade secrets, that is not covered under this law. This law only covers personal data, which is data related to individuals or human beings. Now, of course, Mr. Okello did talk about some of these issues, but we thought it was very important for us to address the participants on this call on why NGOs must register. The law applies to NGOs as collectors or processors of personal data in Uganda. If you recall, when I talked about who does the law apply to, which is Section 1 of the Act, it has no exceptions. To read it verbatim, it says, this Act applies to a person, institution, or public body, A, collecting, processing, holding, or using personal data within Uganda, B, outside Uganda, who collects, processes, holds, or uses personal data relating to Ugandan citizens. Now, I know that NGOs collect a lot of data from your staff, from the vulnerable people that you support. You collect sensitive data in terms of children's data. Many of you are operating within the health sector, and for you to offer this service, for you to provide this service, the first thing you do is to collect that personal data to enable you identify the people that you're supporting. Secondly, NGOs fall in the category of data controllers, data collectors, and data processors as defined under the law. Thirdly, as NGOs, I've already mentioned this, you collect a lot of personal information, including staff information, supply information, information from vulnerable communities that you serve. And of course, the bulk of the NGOs collect what is defined as special, as sensitive data under the Act, and that is children's data and health data. In some cases, even financial data, especially where you give direct grants to individuals. Under the Act, this is sensitive data, and it requires you to provide higher measures of security to ensure that it is not lost or compromised. Fourthly, registration is a mandatory requirement under the law. Section 29(2) of the Act requires the registration in the Data Protection Register of every person, institution, or public body collecting or processing personal data and the purpose for which that data is collected or processed. Of course, this is further emphasized under Regulation 15(1) of the Data Protection and Privacy Regulations, where the procedure for that registration process is provided for. For those who want to look at the law, the process for registration is further provided for under Regulation 16. One of the things that we've also noticed is that when organizations register with us, that process of registration also gives them a lot of information that is very useful in organizations developing their privacy notices. Because, of course, the registration form will ask who the organization is, who the designated data protection officer is. There's a lot of detail on what information do you collect. Do you collect financial information? Do you collect health information? Do you collect preferences? Do you collect visual information? The system is actually very clear and helps you to go through that process. We would expect that as you go through that registration process, it will also give you a better understanding within your own organization how you're processing personal information. In many cases, when I talk about the Data Protection and Privacy Act, I normally emphasize the principles that are provided under the Data Protection and Privacy Act. These principles are core to compliance with any privacy law you will meet. I know many NGOs have representation in Europe, they have representation in the US, they have representation within Africa. This law is not unique to Uganda. Actually, in Africa, you'll find that the Western and the Western Africa especially have been dealing with privacy, data protection and privacy laws for over 20 years. The first country that passed a data protection and privacy law was Cape Verde, which was done 21 years ago. East Africa and Central Africa, we've been slow at adopting these initiatives. Uganda was the first to pass the law, followed by Kenya, which is also implementing this law. So where you have NGOs that are operating, for instance, in Kenya, operating in Rwanda, these laws are already in place and implementation has started. I know, for instance, Tanzania has also issued its bill for public consultation in October. Of course, Europe has been at it for close to 50 plus years. And we found that NGOs that have representation, especially in Europe and the US and in South Africa and other countries, were very quick to register with us, probably because they have a better understanding of what we are trying to do and they need to comply with this law. So there are 7 principles under the law. These are international principles. Whichever country you go to, you'll find that most of these principles are provided for. The wording may differ a little bit, but the principles are the same. And for those who are on this call, every time you're dealing with personal information, just think through how you're complying with these principles. And if you do that, you'll find it very easy to comply with this law. The first principle is accountability, and the law requires that data collectors are accountable to the data subject for data collected, processed, held, or used. In practical terms, this means organizations put in place frameworks that enable them to be accountable to the data subject. There should be a record of why you're collecting personal information. You should have privacy policies in place. You should have mechanisms that enable data subjects to exercise their rights as required under the Act. You should be able to demonstrate your compliance. We started audits last year, a few audits, and some of the things we look for: are your staff trained? Do you have a data protection officer, for instance? If you're sharing personal data, do you have a record on who you've shared that personal data with, and things like that. The second principle is that you collect and process data fairly and lawfully. Fairly means if you're going to share this personal data, you do it in a manner that would reasonably be expected by the data subject. That if you're going to collect and process that data, you have a lawful basis for it. Lawful does not mean that you have a law that authorizes you. It could be that you have a contract with the data subject. It could be that the data subject has consented to you collecting and processing their data. But when you collect that data, how you use it must be fair. In other words, whatever you do with that data must be compatible with the purpose that you disclose to the data subject. The third principle is minimality. Data collectors or controllers can only collect, process, use, or hold adequate, relevant, and not excessive or unnecessary data. So you only collect what you need for your purpose, which means you need to be clear on what your purpose is. If you're an orphanage, for instance, obviously you want to collect personal information on about the person who brought this child. If you know that you'll have to collect personal information that you can access on the parents or the relatives of this child, it would be expected that if this child is adopted, that you will collect personal information of the the parents who eventually adopt this child. But you only collect what is necessary for your purpose and nothing more. The fourth principle is that you only retain personal data for the period authorized by law or for which the data is required. Now, if you're a public body, it's easy to say, I have to collect this for this period of time. Even for NGOs, there may be certain requirements from the NGO Bureau that we request this information for this period of time. So you keep it for that period. However, the law recognizes that in some cases, the law may not provide for that. The period is now prescribed by the purpose for which you collected this information. What the law requires of you is to document that purpose and indicate the period you're going to keep this information. So if it is 10 years, you disclose it in your privacy notice, so that a data subject will know, will have those details with them. The fifth principle is quality, that you must ensure the quality of information collected, processed, used, or held. We all know that if personal information is not of good quality, it can create discrimination. Some people may not be able to access services. Certain decisions may be made that may be adverse, to a data subject, just because the personal information that the data controller has is not accurate. The sixth principle is transparency. And I think this is very clear to the NGO sector. You must ensure transparency and participation of the data subject in the collection, processing, use, and holding of personal data. This means that you issue privacy notices that tell these individuals why you're collecting their data, how you're going to use their data, who you're going to share their personal data with, how long you're going to keep that data, who they can reach out to in case they have a challenge, and things like that. And generally, who are you? Who is this person that is collecting my personal information? Lastly, security. Once you collect this personal data, it is your obligation to observe, to ensure its security and ensure that it's not abused. And this abuse mainly takes place within the organizations themselves, that you don't lose this information, because in many cases, when you lose this information, it can end up in the wrong hands. What do we expect of data controllers? What would compliance mean? Of course, this is not exhaustive because of the time, but there are certain basic things that we expect from the organizations. We expect that NGOs will establish and maintain comprehensive data protection compliance programs within your organizations. And normally, this is done through the development of a data protection and privacy governance framework within your organization. Some of the key issues we look for in a governance framework is that this organization has designated a data protection officer. The data protection officer is our contact person with your organization. We would expect that this data protection officer is trained to be able to do their job. This data protection officer will be the one to assist the organization develop its compliance program. We expect that you register with the office because it's mandatory, it's a requirement of the law. You'll have training plans within your organization to train all staff that are involved in personal data processing operations about the Act's requirements and the impact of non-compliance. We find that, yes, the CEO may know about the law, the managers or the heads of department may know about the law, but even that person at the reception, or that person, the community officer who goes to the community, needs to know about this law so that they are able to articulate what is required, so that they are able to ensure compliance, so that they know what is expected of them. And you can only get that by ensuring that all your staff are trained. It's important that organizations develop an internal data protection policy and privacy notice. The data protection policy enables you to do your data mapping so that you know who is collecting what information. I always give the example of the marketing team. People think these people are just, putting out flyers or things like that. But even the marketing team collects a lot of information. Your procurement office also collects a lot of information on your suppliers. And then, of course, the privacy notice is that information you provide to all of us who interact with you in a brief manner, so that we understand why you're collecting our information and how you're going to utilize it. There are other measures like putting in place, reporting lines. Issues to do with privacy must be represented within the board, within the management team, and then cascade downwards. And then, of course, you must have data subject request resolution mechanisms, because that is a requirement of the law. Organizations are required to ensure personal data is processed lawfully. And you process personal data in many ways. One, you can obtain the data subject's consent, or if you do not have that consent, you must ensure that you're performing a contract with the data subject, you're complying with a legal obligation, or you're either performing a public duty and you're a public body, you're doing it for medical purposes. If someone collapses, you're obviously not able to get their consent. And then the prevention, detection, investigation, prosecution, or punishment of an offense or breach of the law. This is specific to the public sector organizations such as Uganda Police and the others who would be investigating crimes. NGOs would be expected to ensure that any further processing or secondary use of personal data is compatible with original purpose. For instance, if you collect personal data of your staff members, it is expected that if you share this information with URA and NSSF, that is within the law, because the law requires you to do that, and it's still compatible with the fact that this is your staff member and they are required to do this. What is not expected is for you to get this database and share it with a money lending organization. That would not be compatible with the original purpose, because if you're going to do that, then you should get the consent of your staff members. It's important, we normally highlight this because we find that sometimes, or many times actually, a lot of activities are outsourced. But even when you outsource those activities, as long as these providers or suppliers have access to the personal information that you collect, you have to ensure that the contracts you sign with them provide a guarantee that they will implement appropriate technical and organization measures to protect the personal information that you have. In other words, they would also be expected to be compliant with the law. If anything happens to that information, you're still liable. So it's important that in your contracting processes, you add those aspects. And this includes ensuring, yes, that these people comply, but also giving you powers to be able to monitor or their compliance levels so that you protect yourself. Organizations such as NGOs are expected to embed data protection operations, data protection into your operations. We call this, if it's a technology tool, we call it privacy by design. We think that if you think about privacy before, then it will be very easy for you to implement. So you do this by developing and implementing personal data policies on retention, data security, breach response and management, provision for data protection impact assessments under certain circumstances, including where the processing is likely to result in a high risk to the rights and freedoms of data subjects, and then implementing technical and organization measures appropriate to the risk posed by the processing. Organizations are also expected to take steps to facilitate the exercise of data subject rights. This includes, for instance, implementing internal policies and procedures to facilitate the exercise of data subject rights. In other words, you provide for a procedure within the organization that guides your staff. What happens if someone sends out an access request? What happens if a data subject wants you to stop processing their data? What do I do? You need to guide staff so that when these requests come, they already have modalities, they have a procedure to deal with these issues, rather than wait until this matter comes up and then you have letters going around the organization. The law provides certain timelines within which you're supposed to respond to data subject rights. You're required to review and revise your privacy notices, policies, statements, or disclosures to ensure that they comply with Section 13 of the Act to provide certain information to data subjects. And then, of course, within your policies, you have to clearly communicate the data subject's rights. There are a number of benefits to compliance. Of course, you're a good corporate citizen if you're compliant. The respect of data subject rights, given that I'm talking to the NGO sector, I think I don't have to overemphasize the need for that. The right to privacy is already provided for under our Constitution. In terms of issues related to personal data or personal information, there are a number of rights that have been given to individuals like myself and yourself, and it's incumbent upon you to show that you are an organization that respects data subject rights. Good reputation and brand. We all know the value of information assets. It also reduces your legal risks when you're compliant. I'll briefly talk about some of the rights under the Act, data subject rights. One of them is a right to access personal information. So if I suspect that you have personal information about me, I can write to you and ask what information you have about me, how you're using that data, who you've shared that personal data with, and the law requires you to respond. The right to prevent processing of personal data that is likely to cause damage or distress to the data subject. I can talk about maybe an example where someone has been convicted of a crime, but they've served their sentence. But then every time they want to, they go to ask for a job or something, their record comes up. Given that they've already served their sentence, this data subject can actually request that the processing of that personal data be stopped. The right to prevent processing for personal data for direct marketing. However, the law allows a data subject and an organization to enter into a contract for that organization to process their personal data for direct marketing for a pecuniary benefit. The right to correct inaccurate personal data and others. What is expected of our staff? Because we know that these policies must be implemented by staff. Staff are expected to understand the organization's policies on data protection and implement them. They need to be able to understand their responsibilities and abide by these policies. And you can only do this by putting in place these data protection policies, publishing them within the organization, and creating awareness within the organization so that you make sure that a staff member does not release personal information contrary to what the law requires. As staff are expected to report data security breaches to the data protection officer. This data protection officer is within the organization, and the data protection officer is then expected to deal with the incident and ensure that appropriate measures are put in place. For instance, if there has been a data breach, it's important that organizations, depending on the circumstances, inform the affected individuals that their information was stolen or things like that, so that they can take measures to protect themselves. The law requires that where there's a data breach, that breach is reported to the office. Staff are also expected to seek guidance in privacy matters. So this data protection officer is very critical because they'll guide, because we know you'll be dealing with different issues on a daily basis. So that person has to be knowledgeable. They have to be trained to be able to support your staff. Then, of course, staff are expected to implement applicable information security practices, because the bulk of us have all this information within information systems, even if it is in manual depositories, it has to be under lock and key. I normally give the example of HR people. If you're processing staff files, you don't go for lunch for an entire hour and you leave all the files on the desk. We've had incidences where I think one of the breaches that we investigated happened because an HR person was processing the payroll and they ended up sending to all staff instead of maybe to the finance team. And you can imagine what happened after that. So password protection is important, clean desk policy, even prudence in terms of what staff are doing. Staff are expected to enforce their rights as data subjects and of course create awareness. So I hope that the 123 people on this call will also amplify what this law provides and amplify what data subjects are there and be able to support us in create this much needed awareness. There are a number of consequences for non-compliance. Of course, some of them include damage to the reputation of the institution. We've had instances where NGOs, especially in Europe, have had data breaches, and that has impacted their ability to even raise funding for their operations. We've had big tech organizations that have paid a lot of money and have lost customers because there were data breaches. No organization or no individual wants to share their personal data with an organization that they know will either misuse it by either selling it, by altering it and things like that. So compliance is very important for the reputation of the organization. The law has a number of fines depending on the offenses, from 240 currency points to 2% of the institution's annual gross turnover. A currency point is 20,000. So I think 240, my math is not the best, but it should be about maybe 4.8 or thereabout or something like that. The law provides for imprisonment of fines of every officer of the institution who knowingly and willfully or willingly authorized or permitted such non-compliance with the Act. This law actually lifts the veil for the lawyers on the call. This means that where an organization is non-compliant, the PDPO can actually say that the PDPO has identified as having contributed to that non-compliance. So while the organization will get a fine, the officer will get the incarceration penalty. The jail terms stem from between 3 months to 10 years, of course, depending on the offense committed. And then, of course, I cannot overemphasize the personal responsibility for officers who knowingly and willfully authorize the contravention. Offenses I can talk about are failure to register with the Personal Data Protection Office. A sale of personal data is illegal. Unlawful destruction, deletion, concealment, alteration of personal data, and Unlawful means that you don't have the consent, you don't have the legal basis to be able to alter this personal data. Unlawfully obtaining or disclosing of personal data. When I interacted with the NGO Bureau, I really stressed the issue of disclosing personal data. If you're an officer, disclose personal data under this law, you can actually be prosecuted, issued by the office. The office gives us rights or request to correct their personal data. The law requires the organization to implement that request within a given time. However, the data controller or the organization can deny that request, but they have to provide reasons for that. If the data subject is not convinced, the law authorizes them, or with the personal data protection officer, and is valid, we have powers to comply with that notice that we've issued, then that becomes an offense. Which then we can prosecute you for. For registration is an offense, or its protection or without obtaining is an offense, and then processing of duration, the various exceptions that are provided for under the law. In terms of the way forward, we request NGOs to register with the law. I've already highlighted why you must register. Mr. Okello did extensively talk about the fact that the notice that was given to you under this circular was short. If you recall, this law was passed in 2019. Yes, the regulations were done in 2021 and published in March. We started enforcing in August 2021. We did a lot of sensitization, radio, TV, on our social media handles to communicate the need to register. Of course, we know that the NGO Bureau is your regulator, and we wanted to make sure that the NGOs get on board, and that is why that circular was issued. It is not specific to the NGO sector. Registration is a requirement for any organization that is collecting personal data in Uganda, and this includes the public and private sector. So we've been at this registration request for over a year, and we urge you to please cooperate with us and register as is required. What we have done, we have made the registration process fully automated. So you can sit in your home as long as you have the necessary information and be able to complete this form. We've provided guidance notes within that application so that you're able to, if you have a question, what does this mean? A pop-up will come and explain it to you to make it easy for you. Before we developed that process, of course, the process was manual, and we found that people were having challenges, because when you would go back and tell them, you know, you've made a mistake on page 1 and 2, they would have to redo the entire process. Now this process is all automated. You just, my colleague Beck, after I speak, will be able to take you through that registration process in about maybe 10 minutes. You're expected to designate a data protection officer. Of course, if you have funding, the reason why the law used designate rather than say appoint, because in other jurisdictions like Europe, you're required to appoint a data protection officer. The legislators were cognizant of the fact that that we may have organizations that may not be able to afford having a new staff on board. This is very evident even within the public sector, because the resource envelope is so small. So if you have the funds, appoint a data protection officer, because they are critical. If you don't have the funds, you can still designate someone else to be able to take on that role. We've seen that most of these officers are either lawyers, IT officers, compliance professionals. We've seen auditors. Anyone that can, do compliance can be trained to be an effective data protection officer. You're expected to develop data protection and privacy governance frameworks. As an office, we have a lot of information on our web portal, which is www.pdpo.go.ug, and Becca will put the link, Becca Juanita will put the link in the chat so that you can all visit that web portal. It has a lot of information. If you need to know more about the obligations of data collectors, you'll find that information there. If you need tools to do self-assessment in terms of understanding where you are in terms of compliance, we are able to provide that information to you. We request that you collaborate with the office to amplify the data subject rights. Given that I'm talking to the NGO sector, you're very good at amplifying things to do with individual rights. I saw Mr. Muhindo from Unwanted Witness. We've done a lot of work with Unwanted Witness in terms of amplifying the need to comply with this law, what data subject rights are required. I know when they see a breach, they write to us. So they keep us on our feet to ensure that this law is implemented, and it is implemented to ensure the privacy of individuals. We ask that you train your staff. For instance, we've had an interaction with the NGO Bureau last week, where we trained, last week or Monday, where it was last week, where we talked to the entire staff of the NGO Bureau. We are available to do that. The law requires that you report breaches when they occur. And of course, we expect that you'll be good examples on best security practices and privacy practices. Thank you very much. That is the overview of the Act. Moderator, I request that you give us maybe another 5 minutes or 8 minutes for my colleague Becca to go through the registration process, or you could guide us on how to proceed. Thank you very much. Thank you all participants for being here and for listening to me.
Okay, thank you, Stella, for that elaborate overview and in-depth discussion on the Act. Your colleague may have the 8 minutes that you've requested for, then we'll step into the next segment of the program.
Thank you, moderator. And as you've said, we thank Stella for the elaborate presentation. My name is Becca Puja. I'm the manager licensing and legal affairs. I'll briefly turn on my camera, then I head over to the demo. Okay, I'm having challenges, but okay, so we thank you. A number of you have reached out, attempted the registration process. Okay, briefly, that's what I look like. I can now turn it off. A number of you have reached out and attempted the registration process. I'm going to make a very brief presentation on what it is. So you complete forms 2 and 3. These forms come from the regulations. And you pay registration fees of 100,000. These fees are also paid at renewal. It's not a one-time fee. So you submit your application within the account that you'd have created. We review the application. Once it's complete, we issue you the registration. Now, what the application looks like, it starts with going to our portal, www.pdpo.go.ug. Just a minute, I get there. So you start by coming here, www.pdpo.go.ug. Then you click register. When you click register, it will prompt you to create an account. So you will fill in the name of the organization's email address. Make sure that you have access to that email address that you indicate here, because that's where the password will be sent, the credentials to that account. Then you put here the phone number of the organization as well, plus the first name and last name of the person creating the account. Of course, we encourage you to read the privacy notice, the questions you've been asking, that you're already collecting this information, but now you're handing it over to PDPO. You're not giving us any information. You're only giving us generalization of the categories of the personal data that you collect. And also you agree to the terms and conditions, then the account will be created. Within the account, this is what it looks like. The forms that I've talked about, forms 2 and 3, they've largely been automated. So there are about 6 steps. So step 1, it will pick up information that you've already given within the creation of the account. Then here, you fill in the details that are required. Then you go to step 2. Now, if you don't have a data protection officer, the person creating the account, or at least who is in charge of compliance activities within your organization, those are the details that you should provide, the person that will be reaching out to. There's a person who asked, how can we train the DPOs? Now, we can't know who to train if you don't register, so that's the importance of registration. Then step 3, you indicate the categories of the people from whom you collect the information, employees, beneficiaries, and the rest. And the different categories therein, you check the boxes. Remember, this is not just about the beneficiaries, but also your volunteers, employees, and the rest. So step 4, you will indicate the purposes for those different categories for which you collect the information. The total records that you have is optional. In case you have them, you can indicate. But the retention period, this is a general one for the different categories, should be indicated in numbers. Then the disclosure, definitely these different categories, it could be you're disclosing to the bank for payment, benefits such as insurance, Uganda Registration Services Bureau for filing of company documents, your regulator NGO bureau. So you indicate that plus the purpose for which you share such information with them. Now here transferring, Stella talked about there's some NGOs that are international. So if you transfer information to your sister offices, include the purpose for that transfer and the description of which information is transferred. So if it's beneficiaries, employees, is what you should indicate. Here you do not indicate in a way sort of the purpose. The purpose is already catered for. Now here, if you also have a website hosted outside the country, your email servers and all that, that's where you should indicate which country such information is in transit or at rest, and which information is transferred out of the country. Now here you give us, if you have an information security policy, you attach it, but in case you don't, you indicate the security measures that you employ or implement to secure the information. So this could be manual records or could be electronic records. And then the other is, a number of you have been asking, is it a must to have a policy? No, it's not at registration, but in case you have one, please attach it. But at renewal, I will require you to have the information security policy, data protection policy, records and retention, and complaints handling. But for now, you just need to detail the measures. Why we say you can attach a policy is that it makes the review a bit faster because a policy covers a lot more. Form 3, a number of you have been submitting Form 3s which are not commissioned. Now, the law requires that the information that you're giving us, most especially about transfer, that you have already either done an assessment or you've obtained consent. So that Form 3 is sort of a declaration saying that, you know, you're committing to ensuring that wherever you're transferring this information to, they have adequate or similar levels of protection as accorded in Uganda. Should be signed by your CEO, MD, and commissioned. Now, a commissioner for oaths is a lawyer, really, with a number of years of experience and given a particular title to do that. So if you do not know where to find one, approach your lawyer in case you have one. You ask them to commission the document. If they're not one, they will direct you to where to find one. But please have it commissioned, because if you don't, it makes the process longer. Then you attach proof of payment. Payment is done to Uganda Revenue Authority through an assessment. Here we have a video on our YouTube channel. I'll briefly show you that shows you the process on how to generate that payment registration number, where you can pay to a commercial bank or through mobile money, and then you attach. Now, mobile money, you can take a screenshot, put it in a PDF, and attach that document. URA usually, if you indicate an email, sends confirmation of payment, attach that to, then you indicate the name of the person submitting the documents and their title, and that's how it is. So the certificate is also issued electronically. So moderator, just 1 minute to show them where they can get that information on YouTube. So that I can open up to you for the questions. So once we've reviewed and approved the application, you just come here and then you print it. You don't have to come to our offices. As you can see, it will have the number of the certificate when the application was approved and the signature of the National Personal Data Protection Director. So everything is done within that account. Now, you go to YouTube, you in the search bar, you put in PDPO Uganda. So we have videos. So you go to where the videos are, and you go to the playlists. Now we have different playlists. So we have those of people who have been asking about our prior trainings. You can view the full playlist that has all the trainings that we've been conducting, or understanding the role of a data protection officer, developing a framework, how to prepare the report. But my focus here is on registration. So a number of you have been having challenges generating the PRN. So there is a video on how to register and pay. There is a short length, and then there is which is about 8 minutes. Then there is one of a full 1.5 hours. So please start from there. Where you have challenges, then you can reach out to us. Otherwise, that's the registration process and where you can get help. Thank you. Over to you, moderator.
Thank you for that on how to see a number of suggestions and comments have been coming in the chat section. So at this the participants, and we have two regulators here. We have the Personal Data Protection Office and the NGO Bureau. And maybe just to go through the chat, I see we had a comment from Maureen. She's directed to Stella, and she's asking about whether the Personal Data Protection Office collaborates with the Uganda Human Rights Commission, since it also has a constitutional mandate to investigate breaches of human rights nature. And given the fact that data protection and privacy, we are still dealing with human rights elements. So is there that kind of synergy between those two entities to work together in terms of protecting personal data? But also, Grace, Betty, to be maybe enforced, and that the idea should not really be mainly about enforcing penalties, but perhaps a better way to encourage various organizations that are not aware to become aware and be able to participate in this entire process. And Maureen also did ask Stella that she's looking at the last principle of ensuring security of data. To what extent can this be realized in instances beyond the powers of the NGOs? For example, when there is an office break-in and when there is office break-in and the data holding equipments are stolen. So I think most of the questions are actually directed towards Stella. I see also from Maureen has so much to say. She says, can NGOs be data subjects as well? And I think this one is a very important comment from Maureen, which I had also raised in, I think when Stella had gone off a little bit on the fact that sometimes in the process of submitting, the personal data that is collected and registering with the office, is there a possibility that the organization itself also has its own personal data, which in the whole process, it should be able to protect the integrity thereof? And sometimes it might touch the general fabric of the operation of an organization. And again, organizations do not operate in isolation with the different agencies of government. So where is the integrity of that data that is being collected by the Personal Data Protection Office? Is the Personal Data Protection Office unsullied in that it's protected itself from all these kind of breaches that could likely occur, and then the data that they've also collected is in some form of disarray? Stella, you later on answer concerning that. Then I think I'll open up the floor to the participants. If you can put up your hand, then I'll mention your name and you can just chip in. Can raise up your hand.
Can I respond?
Okay, just a moment. Let's first have questions from or comments from Lindsay. And after Lindsay, we'll have one from Taremwa. Then Stella, you'll be able to respond. Lindsay, the floor is yours. Okay, if Lindsay's taking a while, let's have Taremwa. I see your hand is raised. You can submit your thought.
Yeah, thank you so much, Daniel, and DPI for this wonderful and deliberate conversation. Thank you, my brother Okero and my sister from the Data Protection Office. It's very important that it comes at this time, though I would imagine it is a little bit late. This discussion would have come like a month ago, because most of the things we could be as CSOs blamed for not paying attention to certain policies, but every day there is a new policy being born, there is a new procedure being put in place. Before you understand one, another one has come. Now this has come with a lot of power. Is there any possibility that at least before enforcing these penalties at the end of this month, there is more awareness created, because we all understand what this country has been going through in as far as NGOs are concerned, and the policies and acts and the regulations. Is there any way that this can be at least relaxed a little bit, and then a lot of more awareness be created, so that not many NGOs are caught in the trap? And secondly, what happens to the data that is already transferred or is already shared out there? Does it apply on the same, or that is something that is gone and is in the past? And thirdly and last, alluding to what Maureen put in the chat, we've had several office break-ins, and the major intention of the break-in is taking the information. Now, what happens to the organizations that are affected? What happens to the officer in charge that runs the organization that is affected? What are the legal implications to those organizations? And then I would kind of request that before even this is implemented, we are already talking a lot about the NGO Bureau fine of late registration or something like that, renewal. 240 currency points is way too high for NGOs that are struggling with funding and stuff like that. So is there any way this can also be revised downwards before the fire is lit upwards? Thank you so much.
Thank you for those comments and questions. I think at this point, just let me read a few, Stella, then you'll have the opportunity to respond to most of them, probably those that Mr. Okello can respond to. Also, he'll chip in. But I see Humphrey mentioned something about child protection, and the law requires that, you know, if someone has a right, for example, to require their past record of malpractice of criminal records to be expunged. But other laws do require actually to protect children. For example, if someone has been a criminal per se in a particular line of crime, and you know, if their history has been expunged because they've served the sentence, doesn't that place us in disarray with different laws? And I see Lindsay has quite a number of issues with entities that require people to force people to and visitors to leave identification cards and addresses at the entrance before having access to the facility, whether this is something that is lawful. And also Lindsay asks what you mean by unlawful destruction or deletion of data by NGOs, and is there a need for permission to delete data that is already obsolete? I think at this time, Stella, you can respond to the questions and the queries.
Thank you very much, Daniel. There are a number of questions that came through. One of my colleagues was trying to put them together because as you notice, I presented for over, I think, 45 minutes, and many of them were coming in as I was presenting. So I'll mention them. Then if someone feels I've not addressed their question, they can highlight it. The question from Maureen Kiza was also reiterated by Mr. Taremwa. And she was asking about the last principle of ensuring the security of the data. To what extent can this be realized in instances beyond the NGO's powers, such as office break-ins? What the law requires is that you put in place measures to secure this information. But we also recognize that you may put in place all these measures and still something happens. What is expected of the NGO is to show that they had put these measures in place. If we find that, yes, you had put the measures in place, but something still happened, then appropriate recommendations will be made. Normally, when there's a data breach, we expect the organization to investigate what caused that breach, and we also come in to investigate, especially depending on, for instance, how much data was lost. When we look at, let's say, information systems, you have to put in place those measures, things like encryption, ensuring that people have passwords, ensuring that you back up your data, those common sense things that you're required to do, you're expected to do. This law does not say that if they break into your office, you'll be penalized for it. What the law requires is that put in place those measures. If something happens, you will not be penalized for it as long as you show that you had done everything within your power to avoid this breach happening. The second question was the question on whether NGOs can be data subjects as well. NGOs can be data subjects only if you're collecting information as an individual. So we've had people like accountants who provide accounting services as individuals. Those people have registered because in that process they collect information. But an NGO per se, an NGO that is registered, cannot be a data subject because a data subject has to be a human being. It has to be an individual. I hope that clears the issue. So this law does not talk about, let's say, your trade secrets. I did mention that. It doesn't talk about, let's say, your formulas if you're an industrial company. It doesn't talk about your methodology, let's say, for let's say dealing with HIV follow-ups and things like that. Those are things that are protected under the Companies Act, the Trademarks Act, and all that. This law only covers information that identifies individuals. So when an NGO registers with us, they register as an entity that is collecting personal information. However, there may be instances, and Mr. Okello will clarify that, if they ever register an NGO that comes as an individual, that Miss Stella Libatese, I'm an NGO. I don't think that is the case, but he will clarify and then we'll be able to guide on that issue. So let's remember, this law is purely about personal data, and personal data is that information that identifies a human being, or that identifies me, Stella, and identifies Maureen, and identifies Yona. There was a question from Mr. Moses Wangadia. Does this law provide for a time period in which data on children can be destroyed? Because you can't have physical files forever. What this law requires is that you retain that information for the period authorized by the law or for the period you need it. In other words, you must determine what is my purpose. I'm supporting orphans from the age of 1 year to 18 years. That means you're going to keep that information for, let's say, maybe 25 years. So that even after this person leaves your care at 18, you're able to have some information about them. So it depends on your purpose. So that retention period is determined by the respective organization. However, once you determine that period, then you must communicate it to those people whose information you're collecting. So the law you will not find the law saying for children's data, keep it for 10 years, because we don't know how you're using this data. We don't know how long you need this data. That is determined by you, and you provide for it in your internal privacy policies. And of course, you publish it in your privacy notice so that whoever you're receiving information from has they have this knowledge. Maureen asked about synergies with Uganda Human Rights Commission. Of course, the rights that we are talking about international are called digital rights. And we have synergies with Uganda Human Rights Commission. The law actually requires us to cooperate with other organizations, ministries, departments, and agencies. We don't yet have a formal process, but we don't envisage a situation where we are maybe working contrary to each other. Or for instance, if we find that a matter has been submitted to Uganda Human Rights Commission, we can still support Uganda Human Rights Commission to resolve those issues. However, as a lawyer, legally, if it is something related to digital rights and you want to process a claim for your client, you have to look for where the law directs you to go. So if it is an issue to do with access to information or someone has irregularly shared your information, you come to the Personal Data Protection Office. Betty Bwanika, is there a possibility of supporting organizations in training our data protection officers? For us, what we provide is being available. Like when DPI reached out to the NGO Bureau, the ED asked me for my availability, and I'm here to present. We do give training. We also conduct MasterCard events sometimes. We have one coming up in November for data protection officers. When Becca was presenting, you saw that we have a lot of information on our YouTube channel. Very, very valuable information. We do it ourselves or even get subject experts to talk about topical issues. For instance, on the role of data protection officers, that training is already there. So we encourage you to make use of our YouTube channel, to make use of our web portal. There's a lot of information that is there. Our aim is that because we are very, limited on the ground, we are very sparsely resourced. We want as much as possible for people to be able to provide these services wherever they are conveniently. So that's why those videos are there. However, if you need any specific training, you can reach out to us and we'll be able to provide you that support. Someone was saying, Peter Mwevesa was, I think, thanking NGO Forum and DPI for the capacity building in Soga region. Someone was asking, thank you for the training. This is something that is very new and it's like you're creating awareness now. Don't you think that we really need grace period before the penalties are enforced? We've had a number of, Yona has been hinting and hinting, but we've also explained to you that this process has been ongoing for over a year. What is certain is that we have a number, many NGOs actually that are already registered. So it's not a case of, we've not created awareness. We've been on TV, we've been on radio, we've really tried. We did even celebrate Privacy Day last year. There's a lot of content that we have pushed out, and we encourage you to register. This process is not complex. In terms of the financial burden it has on you, it's 100,000. So if you sit in your office, for instance, there are 120 people on this call, you should be able to finish registration within the 7 days. However, we are open to have discussions with the NGO Bureau and provide a way forward. Under our laws, we all know that ignorance of the law is no defense. On our part, we've really tried. We are on all the forums, whether LinkedIn, whether Twitter, even on TikTok, we are there. So we've really, and we've put adverts in the newspapers to make sure that people are aware of this as much as possible. We also request the people on this call to help us to amplify this voice. It's good to register. it is responsible to comply with the law, and we really encourage you to do that. Someone was asking, Stella says that if someone was convicted and served their sentence, that record should not be referred to. I gave this as an example. Of course, what this law does, it doesn't operate in a vacuum. You have to have either the legal basis or a contractual basis for you to enforce your rights, and you have to demonstrate those powers or the ability to do that. I acknowledge that in child protection principles, there is need to declare any past convictions by a prospective employee. That would not be a breach, depending on whether, I know abroad they have, if you're a child offender, they put you on a register that is publicly available, but even then, it happens for a specific number of years. So this law does not work in a vacuum. If the law requires that you stay because of the protection of children on that register, you'll stay on that register. That is why I indicated that even when a data subject makes a request or raises a complaint, the organization, and let's remember, yes, today we are talking about NGOs, but this law covers private and public sector. That organization is required to look into that issue. If they object, they can object with reasons. If the data subject is unhappy or unsatisfied, they have a right to complain to the office. At the office, we'll look at all the necessary laws, we'll look at your basis for denial of that request or that right, and then the law allows us to make a recommendation or determine what needs to be done. If you're unhappy with a decision made by the office, the law provides for an appeal process to the Minister of ICT and National Guidance. And then, of course, there's always a court to go to. I think those were the questions. What happens from Mr. Tarema? What happens to data that is already shared? If that data was shared before 2019, before the law was passed, then you have no obligation. But after that law was passed, you have certain obligation to ensure that the data you shared it in accordance with the law. As I indicated earlier, ignorance of the law is not a defense. There was something to do with unlawful destruction of data. As I indicated earlier, this law is a principle-based law. What I talk about, the offense of unlawful destroying of data means that you do not have the legal authority to destroy that data. I can give you an example. It can be that you have a staff member who you have dismissed. Let's say this is your IT manager, and they go into your systems and destroy all that data. That would be unlawful because they have not been authorized to destroy that data. It does not mean that within your organizations, you don't destroy your data. Remember that within your organizations, you'll have done that privacy framework that tells you this is the data we collect. This is how we utilize this data. We keep it for 5 years. After those 5 years, you're required to destroy that data. And within your policies, you also have to identify how do you destroy the data. If it is paper-based data, Yona, there's a bit of feedback. Someone, Ivan, needs to mute. If that data is paper-based,
Stella, we've lost you.
hello? I think I had muted. Hello?
Yeah, you are now loud and clear.
Okay, where did I stop? I was answering the issue to do with unlawful destruction. Did you hear that of data?
Sure, you can begin from there, Stella.
Okay, so I was saying that destruction of data is unlawful when it has not been authorized. I gave an example of an IT manager who has been sacked, who then goes into your systems and destroys all the data that you have. That would be unlawful destruction of personal data, and that would be an offense. Within your organizations, you're expected to prepare frameworks, data protection and privacy frameworks that detail what information you're collecting, how you're utilizing, how you're sharing it, how long you'll keep it, what happens if you're going to destroy it, and things like that. So you follow those internal processes, but those internal processes must have been documented. That's what the penalty, the offense means. In other words, you're destroying data that is not where you do not have authorizations. And this destruction can happen especially for employees. Someone recently asked me, we are required to recycle, what do I do? You shred that information before you send it over to the people who are recycling. It could be that within the information system, you archive it somewhere, but you make sure that people cannot make sense of that information. So there are many ways that you can destroy this information. The other question I see that came through, the issue of registration fees is not some simple amount you're quoting. Is there any support, especially in the current economic trends? UGX 100,000 is not one you can fix in the budget simply. We've had you, but honestly, I feel that 100,000 is sufficient. That 100,000 also enables the office to support you in doing this work. I know normally the fees are higher, but we thought 100,000 is appropriate. Yes, we understand the economic challenges, but this work must be done and individual rights have to be protected. I would expect that the NGO sector would understand some of those issues. I can tell you, for instance, the office in itself is also understaffed. There was someone asking whether we can provide some support. When we come to train or make presentations to you, you don't pay us. Of course, in due course, we are planning to do a privacy academy where you can bring your staff. We give them comprehensive training at a fee. We expect that when that comes through, the organizations will be able to budget and make provision for this. Dear presenters, are not-for-profit companies limited by guarantees required to register. When I started this presentation, I did state who the law applies to. So there are no exceptions in whatever manner you're registered. If you're a public body, if you're a company limited by guarantee, if you're a private company, you're required to comply. Under Section 1 of the Act, it says this Act applies to a person, institution, or public body collecting, processing, holding, or using personal data within Uganda. So there's no difference. Actually, if you're an individual and you're collecting personal data as part of your work, you're required to register. Uganda has several laws in place, but the dissemination to the local citizenry awareness is minimal. How better can these laws be brought to local citizens' understanding? Our plan is to, first of all, some of the funding that we are looking for is to provide for to provide for translation of these laws. Some of the radio presentations we've made have been in local languages, but of course, within the office, we can do Luganda, we can do, I think, Atesot, we can do a bit of Runyachitara. That is where we stop because that is our capacity. But we are looking for funds to be able to translate these laws. And of course, we call out to the NGO sector, if you're able to assist us with this, we are happy to do this. We believe that once we translate these laws into the local languages, we'll be able to develop content that speaks to our local citizens or rural. I think the right word is the rural citizenry, so that they better understand their rights and are able to enforce them. The other question was, I still see housing and university apartments forcing visitors to leave IDs at the entrance. As I indicated earlier, this law does not work in a vacuum. People collect that information for a certain purpose. They want to identify who enters into their building. What is critical under this law is that they've informed you, and that once they have that information, they will use it for that purpose. In other words, I would expect that if an organization is collecting information on people who are accessing their building, that they maybe destroy it every year. So that, because you'd expect if I'm investigating a crime or whatever, it's unlikely that this issue will come up after a year. But still, that depends on their internal policies. Of course, if you go to visit an organization and they ask for your ID, they ask for your next of kin, they ask for your detail to them raising these requests. Someone was asking, I think I answered that. Do we need permission to delete obsolete data? No. The permission you need is within your organization operations. Someone says, thank you for the presentation. For the last month, multiplex requires a phone number in order for your payment to be completed. What is required of multiplex is to give you a privacy notice so that you know why they are collecting that personal, that phone number. But that is something we can also take up if you can raise a formal complaint on it. Complaints raising is also automated. You can do it through SMS, you can do it through our system. We've so far received between May when we implemented and September, we had over 1,700 complaints that had been raised. Of course, we were able to go through all of them, and we found that about maybe 30% were related to personal data, and we are dealing with them. Of course, the parking attendants should explain why, or at least if it is a system, a pop-up should come that explains why that information is being collected. So that is something we can take up. I would like to know what is the procedure if I'm required by the security agency to hand over personal data. They have to inform you why they are collecting, why they are requesting for this information. Ideally, the request should be formal. If it's the police, there should be a letter from the CID and things like that. Actually, this law requires that when you receive those requests, you internally evaluate if the law authorizes you to share that information with that particular individual. Personal data shared with court or law firm in case of litigation, that is not unlawful. Stella, in your presentation, you said the law provides a right for the data owner to request his or her data from the organization. If person really wants to know what that organization has on him, does the law provide a time limit for the organization to reply? Yes, it has a time limit. I'll mention that time limit because all the procedures, all the rights that are provided for have time limits within the regulations. Can the DPO partner to disseminate this information with some NGOs because we are on the ground? Yes, but we can partner with NGOs, but obviously our funding is limited, so we can have those discussions. We have no problem with that. Someone is saying, can one register for the account, then make payments later, or it has a deadline? Unfortunately, the payment is part of that registration process. So you will not be able to conclude your registration process without making that payment. I think I've answered most of the questions. There's one from Ongatai. What is the difference between the visitors book in an office and data registration records? There's no difference. The visitors book is just one of those forums where you're collecting personal data. And in the expectation in complying with this law is that organizations will do data mapping to know what do the various departments collect. For instance, admin, if they are the ones in charge of the reception, they will know that from our visitors book, we collect this personal information. Do we need all this personal information in the first place, or we just need a copy of the ID, and then they'll determine. Then you will go to marketing. What information do they collect? You go to procurement. What information do they collect? So there's no difference, really. I hope I've answered that question. Is there a law that allows me, the data subject, to know the organization data policies? What we are enforcing is to ensure that organizations share what we call a privacy notice. That privacy notice briefly tells you why they collect, who they are, how they share. That is what you need to know. You cannot go into, let's say, the individual organization and start querying their systems. You rely on what they provide to you in their privacy notice. If they don't comply with what they've disclosed, then you can raise a complaint. Where has the registration form gone? Samuel, I don't know. I think that is addressed maybe to DPI. Okay. Enoch, thank you very much for the information. Although I understand there were press releases, how else other than the PDPO website, and is this info being disseminated? Yes, we did radio, we did TV, we did newspapers, we did Twitter, we did as much as we can. Obviously, we are dealing with 40 million Ugandans. Many of them may not know, but we encourage you, Enoch, to continue sharing. Actually, one of the reasons that we went to NGO Bureau and why you're here is that you got a direct requirement or a direct awareness on the need to register. And we hope that because we know that the NGO was able to reach all of you where you are, that it was able to reach you wherever you are. Those are some of the measures. In some cases, we actually write to these organizations, especially when we are dealing with the regulators. So we've done everything we can to be able to raise awareness, and we encourage you, or we implore you, to continue amplifying this voice. Thank you, Stella. Share with us the link for registration. That link has been shared below. Okay. Okay, I think those were all the questions that
Okay, we've lost Stella there for a bit, but I think she has succinctly responded to all the questions, both those that were asking verbatim and those that were sent through the chat. I saw Humphrey's hand up, but I do believe, Humphrey, a number of questions you had raised were responded to. I see Onenkan and Mohindo Morgan. Probably you can just in a minute, because we are past the time scheduled for this discussion. Just in a minute, Onenkan and Morgan Mohindo, your hands up. You can make submissions, and then subsequently I'll invite Yona to bring this to a close.
Yes, thank you. Thank you, Daniel, for giving us platform, and the team from the protection of data protection office and end use bureau. I have concerns on the system on the registration form. We tried to do the registrations, but we uploaded all the required documents. But now the option to submit is not active. So I don't know if Stella can respond why is it not active, because we tried even to call their office, but we still experience the same problems. Secondly, there is issue of registration. It looks like the registration is annually. Every year you must do registrations. So I don't understand of that. I don't know if Stella can, if she's still there, she can respond on the registration. It is once, and maybe there is a renewal or something else. So I don't know. Thank you very much.
My colleague Stephen will respond to that.
Okay, before Stephen comes in, let's have Morgan also make his submission. I also saw another person with the hand up, but Morgan, floor is yours, just in a minute.
Yes, Daniel, thank you for this opportunity. I would like to thank Yona and the team at DPI, then plus the PD, the Office of the Data Protection, for this wonderful presentation. My question goes to the ED, the NGO Bureau. At what point is one required to have a certificate of registration from the DPO's office? Because we know for a fact that under other regulations, now for example, the National Payment Systems Act, before you obtain a license, you're required to have a certificate from the DPO's office. So is this something that also applies to NGOs that are applying to the NGO Bureau? I'm wondering.
So let us have Queen also share your thoughts in just a minute.
Oh, yes. Good afternoon, everyone. Thanks for this opportunity. So my question was registration of an organization that's basically dealing with refugees. Are there any constraints? Thank you.
Okay, thank you. Just respond to Morgan before Stella's colleague comes in. Morgan, Mr. Okello sent in his apology. He left the platform to step into another meeting, but the question is taken under advisement, and we have a platform, the DPI platform, on which we will be able to have him respond to this, and you'll find the response to your question. It will be reached out unto him, as well as I saw requests for the presentation made by Miss Stella to be shared. You'll also find it on the DPI Talk to Your Regulator platform, as has been shared by DPI. So at this point, let me welcome the responses from the Data Protection Office.
All right. Thank you, Daniel. I will respond to Onenchan's question about registration. Our apologies if you've not been able to succeed with the registration. We'll get in touch offline and ensure this succeeds. Other than that, everyone else, it's been a smooth process. We just need to look into your account and see what the problem is. The issue of registration annually, just to make a clarification, it's a renewal that you're going to be doing annually, in that you don't have to resubmit everything. We're doing this to cater for instances whereby, say, probably after 1 year, you've changed the DPO, or you've changed a little bit on the information that you collect. We want to keep abreast on the information that you have in regard to data protection. So the annual is not registration, but renewal to ensure that we cover any case of changes made. And it's the same process done online. If you do not have any changes, you just move through and keep everything as is until the renewal is provided. Thank you so much. I hope that clarifies. We'll get in touch with you on Enchan to ensure you complete the registration.
Okay, thank you for responding to those, Stephen. Also, I see someone has asked when the training in November is going to take place. Probably it can be shared in the chat section. Hands raised at the moment, so I would love to welcome again Yona to pick it on from here and give us closing remarks. Other than that, all the information that has been deliberated here has been recorded, as well as the questions that have not been answered. The answers will be available on the site and the presentations as well. Yona, the floor is yours.
Thank you, our moderator, Daniel, for guiding us through this process from the time we started up to now. I'd like also to take this opportunity to thank our dear keynotes. That was the ED of the National NGO Bureau, and also the Director, Personal Data Protection Office. Thank you, Ms. Stella. Thank you, Brother Stephen Okello. As you might have heard, the tones, the comments, the question, the concern was, this is a new song into the ears. We really acknowledge the goodwill for the reminder to again comply with this legislation. We really appreciate the intent of the data protection, but we do seek that the two entities, one, revisit the current deadlines and set an extension to allow the NGOs acclimatize themselves with the process. The other aspect is we also seek that you do not enforce the penalties as highlighted in the communication from the NGO Bureau. Ms. Stella, I know we've been hitting and demanding hard on this, but we've already had an appeal statement written. We are circulating it to the NGO sector, and we shall be able to submit our plea in line with the request for extension and other consideration in line with this law. We are really willing to cooperate in amplifying, as you've highlighted in your presentation, but we seek actually an extension that you do not apply or enforce the penalties. It has been a great opportunity to hear from you, and we shall continue again with the talk to your regulators on other panels. There is a question that has been asked to our brother Stephen Okello, who actually stepped out, about registration. Our next series of the meeting, which is next month, end of November, is basically going to talk about registration of processes. Again, we intend to bring back the Uganda Registration Service Bureau and the NGO Bureau, because there are a lot of concerns in line with the process of registration and renewal. There are still many issues in the sector about that. I would like also to take this opportunity to thank members of the civil society sector who have responded to the short call to come and learn through this process and saving their data, taking their time, 2 hours, almost and a half now, to listening to this. We are in this together, contributing to a civic space, getting to create awareness on the compliance obligation, but also raising the concern where we feel that the sector is overregulated. Thank you, ladies and gentlemen, colleagues and family. I declare this session closed. Maybe I request that members put on their cameras for just a photo shoot remotely. Please turn on your cameras and our digital team will help us take the photo. We are going to observe the data protection law.
Yeah, and our privacy notice should have been published. But thank you so much, DPI, for this opportunity. And I want to thank all the members who have joined us and have stayed on the call. What I want to assure you of, we are a very responsive office. If you have any challenges, please get in touch with us. The request made by DPI, of course, we'll have to discuss with the NGO Bureau, but we know we've made this process as easy as possible, minus the need, of course, to pay the 100,000. We think it's a very, very easy process. Please join the rest of your other colleagues and register. It's good for all of us. Indeed, we are in it together. Thank you so much.
Thank you.
Yes,
I think the photo is taken. Thank you once again and enjoy your week.
Okay, good day to everyone. Thank you, Yona. Thank you, our participants. And if you've not registered, please make sure you register on the link that was shared in the chat to ensure that we have record of your attendance and participation in this conversation. Other than that, I will be taking leave and I'll see you the next time we have another engagement.
Okay, thank you.
Thank you very much.
Thank you very much indeed.
Thank you. Bye-bye.
Thank you. Bye-bye.
Bye-bye. Bye-bye. Bye-bye. Thank you.